Introduction to workplace privacy. The concept of privacy in the workplace has undergone significant transformation over the years. Initially considered a straightforward issue, it has evolved into a complex interplay of legal, ethical, and technological challenges. This evolution reflects broader societal changes, including advancements in technology, shifts in workplace culture, and the development of new legal frameworks. Today, workplace privacy encompasses a wide range of issues, from surveillance and monitoring to the protection of personal information and the balancing act between employer interests and employee rights. Workplace privacy concepts. Human resources management. Human resources, HR, management plays a pivotal role in safeguarding workplace privacy. This responsibility includes managing personal information, ensuring compliance with privacy laws, and fostering a culture of respect for privacy within the organization. Our professionals must navigate the delicate balance between collecting and using employee information for legitimate business purposes and protecting employees' privacy rights. U.S. agencies regulating workplace privacy issues. Several U.S. federal agencies are involved in regulating workplace privacy, each with its specific focus areas. Federal Trade Commission, FTC. The FTC is a key player in protecting consumer and employee privacy. While its primary mandate is to prevent deceptive and unfair business practices, it also addresses privacy issues related to consumer information, which can include employee data in certain contexts. Department of Labor. The Department of Labor, DOL, oversees compliance with labor laws, some of which touch on privacy issues, such as the confidentiality of medical information under the Family and Medical Leave Act, FMLA. Equal Employment Opportunity Commission, EEOC. The EEOC enforces laws that protect employees from discrimination, which can include privacy violations related to personal information. National Labor Relations Board, NLRB. The NLRB deals with the rights of employees to organize and collectively bargain. Privacy issues can arise in the context of employer surveillance of union activities. Occupational Safety and Health Administration, OSHA. OSHA's mandate includes ensuring safe and healthful working conditions, which encompasses the privacy of health information in the workplace. Securities and Exchange Commission, SEC. The SEC regulates financial privacy issues, including those related to employee stock ownership plans and insider trading policies. U.S. anti-discrimination laws. Several U.S. laws provide protections that, while not exclusively focused on privacy, have significant implications for workplace privacy. Civil Rights Act of 1964. This landmark legislation prohibits employment discrimination based on race, color, religion, sex, or national origin. Privacy issues can intersect with discrimination, such as in cases where employers misuse personal information in a discriminatory manner. Americans with Disabilities Act, ADA. The ADA prohibits discrimination against individuals with disabilities and includes provisions to protect the privacy of medical information in the workplace. Genetic Information Non-Discrimination Act, GINA. GINA prohibits discrimination based on genetic information, including family medical history, and sets strict limits on the acquisition and disclosure of genetic information by employers. Navigating workplace privacy. The intersection of technology, law, and ethics has made navigating workplace privacy increasingly complex. Employers must consider various factors, including the legitimate business need for information, the privacy expectations of employees, and the legal framework governing privacy protections. The role of technology. Advancements in technology have transformed the workplace, enabling new forms of communication, data storage, and surveillance. While these technologies can enhance productivity and security, they also raise significant privacy concerns. Employers may have the ability to monitor employees' online activities, track their movements through GPS, and collect vast amounts of personal data through digital platforms. Balancing the benefits of these technologies with the need to respect employee privacy is a critical challenge for modern organizations. Legal and ethical considerations. The legal landscape of workplace privacy is complex, with numerous laws at the federal and state levels addressing various aspects of privacy. Compliance with these laws is essential, but it is also important for employers to consider the ethical dimensions of privacy. This includes respecting the dignity and autonomy of employees, fostering a culture of trust, and ensuring transparency in how employee information is collected, used, and protected. Conclusion. Workplace privacy in the United States is a dynamic and multifaceted issue. As technology continues to evolve and the legal landscape shifts, employers and employees alike must stay informed and engaged in discussions about privacy rights and protections. By understanding the regulatory framework, recognizing the ethical implications of privacy decisions, and leveraging technology responsibly, organizations can navigate the complexities of workplace privacy and create a culture that respects and protects the privacy of all employees. In the contemporary U.S. workplace, privacy concerns intersect with evolving technological capabilities, legal frameworks, and ethical considerations. This essay delves into the multifaceted aspects of workplace privacy, spanning from the initial employment stages through to termination, and explores the implications of automated decision-making tools, background screening, employee monitoring, investigations of misconduct, and the management of employment termination. Automated employment decision tools and potential for bias. The adoption of automated employment decision tools, including algorithms and artificial intelligence (AI) systems, has revolutionized recruitment processes. These tools analyze vast amounts of data to streamline hiring, assess candidate suitability, and predict future performance. However, their reliance on historical data and predefined criteria can perpetuate biases, leading to discrimination against certain groups. Concerns arise regarding transparency, fairness, and accountability, prompting calls for regulatory oversight to ensure these technologies do not reinforce existing inequalities. Employee background screening. Federal Credit Reporting Act, FCRA, requirements. Employee background checks are governed by the FCRA, which sets standards for accuracy, fairness, and privacy of information. Employers must obtain written consent from candidates before conducting background checks and provide notice if adverse actions are taken based on these reports. The FCRA mandates that individuals have the right to dispute and correct inaccuracies, ensuring that decisions are made based on reliable data. Methods. Personality and psychological evaluations. These assessments are used to gauge compatibility, work style, and potential for success. However, they must be carefully administered to avoid discrimination and respect privacy. Polygraph testing. Severely restricted in most employment contexts, polygraph tests are subject to legal limitations aimed at protecting individual rights. Drug and alcohol testing. Employers implement these tests to maintain safety and productivity but must balance them against employees' privacy rights and applicable state laws. Social media. Employers may review public profiles to gain insights into candidates' behaviors and attitudes. This practice raises ethical questions about privacy and the relevance of personal life to job performance. Employee monitoring. Technological advancements have expanded employers' ability to monitor workers, raising significant privacy concerns. Technologies. Computer usage and social media. Monitoring is justified by the need to protect company assets, prevent inappropriate use, and ensure productivity. However, it must be balanced with employees' expectations of privacy. Biometrics. Used for security and timekeeping, biometric data collection poses risks related to consent, data security, and potential misuse. Location-based services, PALMs, tracking employees' locations, especially outside work hours, can be intrusive, necessitating clear policies and justifications. Wellness programs. While promoting health, these programs must safeguard sensitive health information against unauthorized access or discrimination. Mobile computing, email, and postal mail. Monitoring these communications requires transparency and adherence to legal standards to respect privacy while protecting company interests. Electronic Communications Privacy Act of 1986, ECPA. The ECPA provides some protections against unauthorized interception of electronic communications, but its applicability in the workplace is limited. Employers often have broad leeway under the business purpose exception, allowing them to monitor communications on company systems. Unionized worker issues. In unionized workplaces, monitoring practices may be subject to collective bargaining agreements. Unions play a crucial role in negotiating the terms of surveillance to protect workers' privacy rights. Investigation of employee misconduct. Investigations into misconduct require careful handling of data, adherence to legal standards, and respect for the rights of all involved parties. Data handling. Ensuring the confidentiality and integrity of information is paramount to fair investigations. Use of third parties. Outsourcing investigations can raise additional privacy concerns and requires strict oversight. Documenting performance problems. Accurate and objective documentation is essential for addressing performance issues without infringing on privacy. Balancing rights. Investigations often involve sensitive information, necessitating a careful balance between the rights of the accused, complainants, and the organization. Termination of the employment relationship. Transition management. Managing the termination process with dignity and respect is crucial. Employers should provide support and clear communication to ease the transition for departing employees. Records retention. Post-termination, employers must retain records in compliance with legal requirements, balancing the need for information with former employees' privacy rights. References. Providing references for former employees involves navigating privacy concerns and potential liability. Employers must tread carefully, offering truthful and relevant information without divulging sensitive details. Conclusion. Workplace privacy in the U.S. is a complex and dynamic field, influenced by technological advancements, legal developments, and societal norms. Employers must navigate these challenges thoughtfully, balancing operational needs with employees' privacy rights. As technology and the workplace continue to evolve, so too will the landscape of privacy, requiring ongoing vigilance, adaptation, and dialogue among all stakeholders.